Okay. Thank you, everybody. I guess I'll start by acknowledging the traditional owners of the land, as everyone does. I'd like to say who I am. I'm Kay Wilson. I'm a PhD student at Melbourne Law School. And I just wanted to thank Endeavour Foundation for inviting me to come today to talk to you about the topic of the evolution of the concept of legal capacity and what I've called a new vision of persons with disabilities. I think probably so far what we've heard about is the reality of the lives of people with disabilities, and this is a bit of a perhaps change in tone because it's a little bit more about what could be. So anyway, it's good sometimes to start with a story. So I'm going to start with the story of the daughter in intensive care and to illustrate some of the issues about how decisions are made. And this is the story. My daughter does not like, this is a mother talking to the House of Lords Committee on the Mental Capacity Act. They had a post-legislative scrutiny report. My daughter does not lack capacity. However, while she was in an intensive care unit, she needed a surgical procedure. I arrived at the unit to be seen by 2 consultants who asked me to sign a form stating that she lacked capacity. I refused to sign the form because she doesn't lack capacity. I was then told that she was ventilated and sedated, so I agreed to sign the form with the addition of a statement that the lack of capacity was related to this situation only. I then went into the unit to find her wide awake. On checking with the nurse, I discovered that my daughter had not been sedated when the surgeon had been in to see her, and that he had made no attempt to discuss the procedure with her or to gain her consent. This man had simply observed her existing physical disability and assumed lack of capacity. Why did I choose this story? Well, clearly it's not the worst case involving the human rights of people with disabilities. We've certainly heard a lot more, but I think it can illustrate some things about the concept of capacity and decision making in a situation which is very personal in terms of person's bodily integrity and right to make and have control over decisions about themselves. And it's a recent real life story. It shows that the denial of legal capacity is a problem for all people with disabilities. In that case it was physical, but especially mental and cognitive impairments. And that it shows that the denial of legal capacity can be based on social attitudes and entrenched attitudes, as well as legal barriers. And in this case, the doctors either just decided by looking at her that she didn't have capacity, or perhaps thought maybe it's easier to talk to her mother and not have to bother with directly engaging with her. And I think it also shows the importance of advocating recognition of legal capacity. And I think we can see in this example that the mother was actually very good in really trying to stand up for her daughter and her rights to make her own decisions. And of course I'll be talking a little bit more about even giving people support to advocate for themselves. Sadly, this is only one example where persons with disabilities have been denied their legal capacity. A denial of legal capacity happens in a range of contexts, some of which we've heard about. People with disabilities often prevented from making basic decisions in life that we all take for granted, like voting, healthcare decision making, marrying, founding a family, parenting, as we've heard from Claire, consenting to sex. And what we've heard a lot about in the last 2 days is the participation in the legal system as witnesses, as victims, as defendants, and also as jurors as well. And in the area of property and financial transactions and guardianship. And in all of these situations, people who've been denied their legal capacity all report the same sort of experience. And they say that the denial of legal capacity has given them a sense of powerlessness and often results in a lack of explanation or an opportunity to actually challenge the process. So this is a roadmap for my presentation today. So I've talked about legal capacity, but I'm going to explore a bit more about the definition of what legal capacity actually is, and talk about the history of and evolution of the developments of concepts of legal capacity and gaps in the current framework. I'm going to talk about the Convention on the Rights of Persons with Disabilities, or CRPD, and its new vision of persons with disabilities, and then talk a little bit about what this new vision might actually mean for persons with disabilities. So, what is legal capacity? Well, legal capacity is a fairly complex and confusing concept. And the Ontario Office of Assessment has said there is as many definitions of capacity as there are jurisdictions that use them. The other thing is to note is that there are differences in the way national domestic laws think about legal capacity and the way it's thought about as an international human rights principle. But essentially, in a nutshell, I think legal capacity comes down to the right to make your own decisions, to have your decisions respected and upheld by the law. It's a legal fiction that draws a line between those decisions that are legally recognised and those that are not. And it's the law's expression of autonomy and people's self-determination. And if we go back to our example of the daughter in intensive care, it was a situation that instead of being able to make the decision herself, as most of us would as the patient, it was assumed that that decision needed to be made by her mother, and a situation where those decisions might be made by a third party. So it's about making your own choices. Now, it's recognised that there are two types of legal capacity. The first is legal standing, and that's to be recognised as a person before the law. And that includes things like having a birth certificate, which in some countries is a problem for babies with disabilities, being able to seek medical assistance, registering on the electoral roll, and applying for a passport. The second area is called legal agency, and this is probably the area that's more controversial and of concern because it tends to be denied more often to persons with disabilities, and that is actually the ability to not just be a holder of rights but to actually act on those rights and have those recognised by law. So I've given an example here because this is what the CRPD committee has put in General Comment 1. The example they've said is that persons with disabilities are often able to hold property, but there are restrictions on their ability to engage in transactions and buy and sell property. So that's an example of that. So it's active legal capacity. So I'm going to talk a bit about the history now of the concept of legal capacity, and much has been written about that in the literature. But I think it's important to be able to see how the concept has developed and to compare that with the new vision in the CRPD. And in conducting this discussion, I'm going to use the structure that's proposed by my supervisor, Bernadette McSherry, in her seminal paper on legal capacity. So the first thing I'm going to talk about is the original way of denying people of their legal capacity, which is called the status approach. Now, under this approach, people are denied legal capacity on the basis of a personal characteristic, and we've seen this happen throughout history, and that can be women, Aborigines, people from particular ethnic groups, people who have a criminal conviction, people designated as idiots and lunatics, and children under the age of majority have been historically, and in some places still are, denied their legal capacity on the basis of who they are rather than their actual ability to participate in decision making. And the other thing to note is, well, Michael Perlin calls this denial of legal capacity permanent and plenary. So it's a complete stripping of a person's rights to make decisions, and it tends to often reflect the views of dominant social groups because it has honestly been thought in the past that categories like women and certain others are actually not just socially disadvantaged but also cognitively and biologically inferior. So it captures that, and as we can see, there's the suffragettes there lobbying for their right to vote. So fortunately though, in Australia and the UK and other countries, we've moved on from the status approach to legal capacity, and we take a different approach, which is called the cognitive approach to legal capacity, and this is a bit narrower than the status approach. It's not necessarily based on who you are, but the conception that people are actually a bundle of different kinds of capacities. And so under this cognitive approach, legal capacity is only denied where a person who is assessed to lack the mental ability to make a particular decision at a particular time. So it's much narrower. It doesn't strip you of all of your rights, only particular ones. And I've used the term mental ability based on the Australian Law Reform Commission report, where they suggested that the term mental capacity can be quite confusing because it can be easily confused with other concepts of capacity, legal and mental capacity. So mental ability is probably a better explanation of that. So the cognitive approach has two types of assessment. The first is outcome-based assessment. And this is the idea that a person should be stopped from making a bad decision that might seem out of character for them, so we don't think it's necessarily their true wishes, but it might also just be a decision that departs from social norms. Under this approach, the law assumes that if a person makes an unwise decision, then they must lack mental capacity, and no further inquiry is made into the reasons why they might actually be making the decision that they want to make. So that's that approach. And that probably would fall within, to some extent, maybe mental health laws and some decisions in medical decision making where people thought to, in general health, where they lack capacity. That often is an approach that's used. The functional assessment of capacity is asking the question of has a person used the right process to actually make a decision? So do they understand the nature of the decision, and do they understand the consequences of it? And what I've put here is a summary of the provision, the Mental Capacity Act Section 3 provision, which talks about the ability to understand the relevant information, retain that information, use and weigh that information to make a decision, and communicate that decision. And this particular formulation is quite popular and seems to be used widely throughout the world, and the Australian Law Reform Commission has suggested using a variant of that in its report. But there are some problems with functional assessment. Mental ability is not an all or nothing thing. Like most human attributes, it falls along a continuum, and so it's very hard sometimes to actually draw the line and have a binary divide between having mental capacity and not having it. Mental capacity requires a high level of understanding. I don't know, do we all make decisions? Do we all go through the Section 3 Mental Capacity Act process every single time we make a decision? Or is it more of a heuristic process? We know what we want, we don't necessarily retain and weigh and so forth. So it's argued that the functional assessment might actually require a higher standard from persons with disabilities than those who don't have disabilities. Anyone who's ever been involved in assessment of people's functional ability would know that it's quite hard to apply. There are obviously all sorts of tools that people use, but it's hard to often get a sense of the level of a person's actual functioning. It's also a very individualistic approach. It doesn't consider what people can actually do if they have advice and support. It's only focused on what they can do on their own, and realistically, most of us will often seek advice, emotional support from friends, family and professionals when we are making important decisions. And it's also been pointed out that it is discriminatory in that it is only applying to persons with disabilities, and it can easily revert to the idea of the status approach, which we've rejected, because a person's actual disability is going to play a fairly big part in how that assessment actually occurs. So when I found this thing, sometimes good people make bad choices, it doesn't mean they're bad, it means they're human. That really appealed to me because I think it often comes up where people with disabilities perhaps feel that they're not allowed to be human like the rest of us and have what's called the dignity of risk and to learn from their mistakes. So that this brings me back to the new vision of persons with disabilities by the CRPD. And if we go back to the story of the daughter in intensive care, that was a situation where through a functional assessment she would have had legal capacity, and it was denied in that situation. But we might think that maybe there's just a systemic problem with a system that allows some people to be denied their legal capacity at all. So when we come and talk about that with the CRPD, it really thinks about a completely different approach to dealing with an inclusive approach to dealing with the issue of legal capacity. So I thought I'd like to start by saying a few words about the CRPD itself and its new vision. There's certainly a lot of interest in Article 12, being probably the most exciting and controversial provision of the CRPD, and it's also thought to be a portal to other rights. But the Article 12 actually fits within a whole convention, and it's a whole convention that is designed to lift the entire status of persons with disabilities. So I think the thing to say is that the vision that CRPD has of persons with disabilities as visible as equal but different members of society. And it really puts the person, in Geneva Richardson's words, centre stage. It is a categorical rejection of the medical model of disability. Once upon a time, the view was that disability was a personal tragedy. It was a very pessimistic view. It was decided that people with disabilities departed from the norm and they needed to be fixed, cured, or treated, or have their symptoms controlled. And this is a complete rejection of that approach because it doesn't locate disability in the person, but embraces the social model of disability and says disability is the product of social conditions and barriers, and that society has an obligation to step in and remedy that. So it changes that view and says persons with disabilities are not objects of charity, but they are subjects with rights. Okay, so what does Article 12 actually say? Well, it says that persons with disabilities should be able to enjoy legal capacity on an equal basis with others. And when we're talking about equality, we're talking about other people with disabilities and we're talking about people who don't have disabilities. And so under this approach, everybody is entitled to have legal capacity. Legal capacity is not dependent on mental ability. Legal capacity is never lost. I know, I thought it was a mistake when I read it, but that's what it is. Legal capacity is never lost under this model and no one gets left behind. It is an inclusive model of legal capacity. But it does offer something, and it says that people should also have support in exercising their legal capacity, and that's what they're entitled to assist them to make their own decisions rather than to have a guardian or, in the mental health context, a doctor or tribunal making the decision for them. It also talks about safeguards to exercise legal capacity, which are designed to prevent abuse. So under the CRPD, the Universal Support Model, the CRPD requires, this is Michael Buck and Lara Kersner's famous quote, a paradigm shift in the law of capacity, so that the question is no longer, does a person have mental capacity to exercise legal capacity? The question is instead, what types of supports are required for the person to exercise his or her legal capacity? So the focus is much more on supports, and I think really from what we've heard so far, that would be something that would benefit persons with disability in a whole range of contexts. So good news, I hear the paradigm shifting. So what is support? Well, supported decision making is what my colleague, who would have been giving this talk if it wasn't me, Piers Gooding, calls an emerging concept, and I think that's right. So I've taken this description from General Comment 1 of the United Nations Committee on Persons with Disabilities. So they say that support can include, and this is an inclusive definition, it is not a limit to the things that could be used to support a person, but they have suggested that it could include assistance from a trusted person, it could include peer support, it could include advocacy, including support for self-advocacy, and universal design and accessibility, and non-conventional forms of communication, even though those forms may only be understood by a few people, and advanced statements, which are quite a big deal in mental health at the moment. The idea that people might be able to express their wishes when they do have capacity and have some forward planning for times when they may not have capacity. So that's just a sample of some of the things that support could include. Other points about support under the support model. The amount and type of support will vary between people because people have different needs. It's very individualistic. So we shouldn't just think that there's, have a checklist of, oh yeah, we've given these supports. It's really looking at the whole person. People are, under this model, entitled to refuse all support. They're entitled to say thanks but no thanks, I don't want support. And tests of mental ability should not be used to assess eligibility for support. And the aim of support is to actually try and build the capacity of the person so that in the future they'll be able to make decisions for themselves. So, the fly in the ointment. What if we give someone all of the appropriate supports that we can, and they still can't make a clear decision that we can recognise? Well, the Convention on the Rights of Persons with Disabilities says that significant efforts to give support must be made. And they have said that if a decision is made by a third party, it should be based on the best interpretation of the will and preference of the person. It should not be made on what is considered to be in their objective best interests. So they've introduced a new concept which they've called substituted judgment. So when I think about substituted judgment, I think about legally putting yourself in someone else's shoes and walking a mile in those shoes and seeing the world from their perspective in terms of gathering information about what they would have wanted rather than what we want for them. So as you can see, the concept of legal capacity in international law really gives an unprecedented, I think probably unprecedented scope for the exercise of autonomy and self-determination. So what might these developments in international law mean for people with disabilities? Well, I think, as we've heard all sorts of things, as we know, what happens in international law isn't necessarily binding. It is binding in international law, but it doesn't necessarily give people direct rights to apply the convention and say, my rights have been breached under Article 12, and go to a court and enforce those rights in domestic law. So it is dependent on the government putting into place national policies and legislations that reflect that. But the existence of the CRPD is there, and it can guide the development of national policy and legislation development. And it may have some impact in the courts, because courts may use the CRPD as a guide when they are interpreting legislation as to what it might mean, especially where there's ambiguity. And you could also be argued that when governments are making decisions, administrative decisions, that people have a reasonable expectation to expect that the government will take into account their rights under the CRPD in making those decisions. But as Graham Innes pointed out, really, the CRPD is an important advocacy tool. And I think international human rights law, it has a certain moral authority because it's our vision of what it means to be human, and that can be used effectively. I also think and point out that the CRPD is an ongoing partnership between the states and persons with disabilities, and what it requires is what Graham was saying. People with disabilities must be involved in the implementation of the CRPD and continue to be involved. So it's not, international law is not necessarily very prescriptive, it's quite high level, and what that means needs to be worked out over time with the participation of persons with disabilities in that process. And also I think that it will take time for implementation to occur and for the promise of what is in the CRPD to be fully unleashed. Moving on. So moving to the support model, the CRPD committee says in general comment 1, state parties' obligation to replace substituted decision-making regimes, that's where decisions are made by a third party, by supported decision-making regimes where a person makes support with support, makes their own decisions with support, requires both the abolition of substituted decision-making regimes and the development of supported decision-making alternatives. The development of supported decision-making systems in parallel with the maintenance of substitute decision-making regimes is not sufficient to comply with Article 12 of the Convention. So the CRPD committee has stated here and has stated elsewhere fairly robustly, takes a strong stance that mental health and guardianship laws should be abolished. However, in terms of my future predictions, using my legal crystal ball as to what might happen here, I can't really see the abolition of mental health law and guardianship laws happening in the short term. But the CRPD has certainly sparked a spate of reviews throughout Australia and overseas of guardianship laws and mental health laws. And it is something that people are starting to engage with in terms of working out what the policy direction to go in this area and to give people more empowerment. And we can see that through the ALRC report that's proposing the national decision-making principles, that might provide what Graham was saying, a framework really moving forward for respect for greater autonomy and self-determination of persons with disabilities. Where I really see things moving and being most promising is perhaps in the greater development of what support is, what different kinds of supports that can be used for persons with disabilities, and the ability in making decision-making support much more available to persons with disabilities. So, and in some ways, I think that the support model needs a lot more development, and there's obviously work going on in Australia and overseas, quite a bit of work going on in Canada about what that might look like and how things like support relationships can be formalised and recognised, and what safeguards will need to be introduced, and so on, is happening. So that's where I really see a lot of progression happening to start with. And I think that in a sense to perhaps move as swiftly as what the CRPD committee is actually telling us to abolish guardianship and mental health laws, without having a proper supported decision-making model in place, might mean that we'd have a similar situation to deinstitutionalising everyone and not having any community services. So I was just reading this in this book that as I was coming up. Gerard Quinn makes a comment about this, and he says, incapacity is not really a black and white issue. It is very much an individualised process. The first thing that a political authority should do is to put in supports to enable individuals to make decisions, rather than take away this opportunity and do the easier thing of letting another person make this decision for them. So in conclusion, what I'd like to say is that I think the idea of the recognition of legal capacity is also a recognition of personhood, and that often I think it's more than just the ability of helping people make those big legal decisions for themselves, but in the literature I think seems to have a bit of a trickle-down effect in terms of recognising even some of the, giving people greater control over some of the smaller decisions, like what to wear and what to eat and what activities to engage in, day-to-day things, in the sense that it changes the whole attitude towards the person with disabilities. So from this perspective, it's a bigger attitudinal shift than the strictly legal one. So I finished off with this cartoon. Always remember you're unique, just like everyone else. And I think that really encapsulates what the CRPD tries to do in broadening our understanding of what is the normal, and greater respect for human diversity. Thank you very much.
Thank you, Karen. Any questions?
Leanne Bassett from La Trobe University.
Yep.
Can you say just a little bit more about that concept of will and preference, and as a basis for substitute decision making, and how that might sit with general comment in Article 12?
Well, I don't think that the concept of will and preference is really all that well developed in General Comment 1. I think they basically probably put it in because they realised that there might come a time where, with all the best intentions in the world, the support model might fail, so they need to do that. And also perhaps a recognition that sometimes it's not always going to be clear what a person's decision might be. Sometimes dealing with these situations, I know sort of in dealing with my son who's on the autism spectrum, you can't always work out what he wants. With the best will and intentions in the world, you are going to be guessing. So I think that's the idea of what will and preference is there, is to provide, I guess, some sort of default to help us try and understand what a person would have wanted based on our knowledge of them, and also interpreting signs that person might give that are a bit ambiguous in terms of making that decision. I think it tends to be very much contrasted with the idea of best interests, and very much saying no, not best interests, which can be a decision made because we know better than you, and we're going to impose our values on you, and we're going to do what we think is best for you. Whereas I think will and preference is really an expression of, I'm thinking of Freyrenhain and O'Shea's discussion of normative internalist values, or decision making based on a person's internal value set. And I think it's really trying to capture that subjective will as opposed to the objective. But it leaves a bit open in terms of, I mean, I haven't given a critique at all of these concepts. That's not really what the purpose of this was, and I've only got half an hour.
It's a bit mean.
Next time I'll give you an hour.
Yeah, but so I'm conscious of that. But at the same time, yeah, I guess I was just aware. I think that whether people can swallow the idea that people might be making decisions that will be bad for them based on their will and preferences is a big ask. Yeah.
Thank you. Patrick.
Sorry to ask this question, but it's been burning on things, but as I I know you're a doctoral student, and I'm just about to ask you one doctoral question. We could sustain another doctorate, but have you given some thought to the implications of the autonomy model for criminal responsibility? Now,
No, but there are other people who have.
I mean, it just strikes me that at some point in your thesis you're probably going to have to address that, even if it's just to say, I'm not going to do this.
Yes. Yes, and I think that's actually an area that, when I look at the literature, hasn't been always that well done. It has been suggested, I'm thinking of Amita Dandra talks about, basically, perhaps similar to what Claire was saying, expanding the general criminal law and using those concepts to kind of deal with differences in decision-making ability. But yeah, that is obviously an issue. And as I said, I haven't given a critique of this. I really was just explaining what the concept was.
Just really two observations. One is that I think it's interesting that you pulled apart the notion of capacity and asserted that capacity can exist where support exists.
Yes.
I think that's a really interesting notion. The second one is, it would appear to me that your understanding of assisted decision making is more an applied ethics discourse than it is a legal conversation, which is far more complex, I would think. So by that I mean that in the applied ethics space, you're really asking what do we understand of the other and how might they relate to these circumstances by observing them, understanding them, and affirming them as a human being, and from that space begin to make some decisions.
Yeah, I think that's in a nutshell. That's fantastic. I have to write it down.
Notion for this issue of assisted decision making.
Yeah. Well, the thing with it is that it is actually requires a lot of effort, I think, and if anything, it's about CRPD is about, I think, reaching out and going past our out of our comfort zones, and the idea is that sometimes people are thought to be unreachable, but maybe if we make more efforts to try to understand them on their own terms, that we might find that even though they have a different way of communicating, a different set of values, and a different approach to things, but we might be able to understand that more and help them reach their wishes and goals and preferences.
Hi, I'm Margaret from the Adult Guardian.
Yeah.
Do you see a dilemma in, for instance, the supported decision-making model when it's the person's supports that are involving them in the criminal justice system? For instance, someone who's in supported accommodation, they smash a chair, police are called, they're charged with willful damage. The support persons around them are the ones who have made the call to have the police involved, and I guess just is there a dilemma there with the supports that are around people who often don't have any other supports for them? There aren't family or peers or friends to assist them in this decision making, so where does the dilemma lie when...
Okay, that's fantastic. The answer to your question is yes, there is a dilemma with that. I think I didn't go into the safeguards that is talked about in Article 12, 4, where it talks about that and issues about safeguards being around supported decision making, around preventing undue influence and probably dealing with those kinds of conflicts of interest. And so on. And I think this is a real problem with the support model, because what I've been seeing in terms of some of the approaches to it, it's often very much relying on a person's natural and informal supports to provide that role, and there really doesn't seem to be all that much around in terms of support officers for people who don't have supports, or like in the example that Claire was saying, I'm not sure if it was you, Claire, but someone was talking about the example where you might want to give details of abuse but not do it in front of your parents. And I can also see roles for perhaps wanting specialist support, such as maybe a speech therapist or someone, to help with assisting understanding and interpreting what a person's will and preferences actually are and what decision they might have. And I do know that there is some work being done by speech therapists with people that we would presumably previously think weren't capable of making decisions by looking at spontaneous non-verbal communication and interpreting that as a way of determining a person's will and preferences.
Yeah, just thank you so much. That's absolutely fascinating. I really enjoyed every minute of it. One of the things that occurs to me also is that it's just so important to really think this through in the context of the NDIS, because the NDIS is an opt-in scheme. It's an insurance scheme for individuals, and I think in the context of the people we've been sort of focusing on prior to in the last couple of days, it is about a decision to apply to become a participant in the NDIS, and a lot of the discussion that's coming out of the trial site in New South Wales is around people with complex support needs and then deciding not to actually have anything to do with another governance system. And so, I mean, I really commend you on your work, and I hope that you'll be able to feed into that debate, which is, I think, going to be, it pulls together the issues around legal capacity and how that operates in a market or a marketplace. That whole neoliberal idea of capacity and choice as a consumer versus, and I don't even know, I'm hoping that you'll be able to really help us understand that as we go on, because I think for the group of people with very complex support needs who've had very negative experiences with services, the NDIS is just will be very difficult to engage them anyway other than via supported decision making.
Yeah, look, I think that they're still trying to work out, other people from the NDIS might be able to add to this, but I think they're still trying to work out how they're going to deal with the support model in the context of the NDIS. The LRC report that Graham was talking about and has been involved with actually has, because it's to do with Commonwealth laws, has a whole section on the NDIS. And so my understanding is with this whole model, I mean, the NDIS is really very much trying to give people choice and to be able to make those decisions. But you're right, perhaps trying to involve people in that, especially given bad experiences in the past, might be quite challenging. And it'd be very unfortunate if people who have the most need will miss out on having the opportunities available that the NDIS and support that it can provide for them. And I think that's always the issue in terms of this whole issue of capacity, is that if you give people too much, if we rely only on the ability of the person to make decisions and say, yes, I want to do this or not, and this is the argument for keeping perhaps mental health laws in place and substitute decision making, the people who are perhaps the most vulnerable are going to miss out because they won't engage, and they don't. And it's not necessarily a case that because they can't engage and they don't want to engage, but that's not necessarily good for them. So that's the paternalistic side.
Thank you. Cut you off. Well, I cut you off yesterday.
Yeah, I've forgotten your name, but you're from the NDIS, so I thought you might have some comment. NDIS. Oh, okay.
Just a continuation of that point, it seems very based on the concept of positive liberties, so there's to prevent people's lives, but also kind of negative liberties, concepts of pride, disadvantage, based on the elected liberties to be positive intervention in my order to for people to make not make decisions based on inequality, inequity, social disadvantage, and so on.
Yeah, absolutely, and that's part of the dilemma. But then sometimes you can have a situation where decisions are made for people against their wishes, and then they don't want to ever go anywhere near services again, especially in the mental health sector. Having forced decisions made, substituted decisions made, can actually have the opposite effect as well, of disengaging people with services, and so they're only dealt with in crisis. But you are right, it is enormously complex, and the CRPD and the CRPD committee just gives us one aspect of the issue, and it's a very, it comes from a particular place of, comes perhaps hearing some of the voices here of persons with disabilities who feel that their capacities have been underestimated by society. I would say though that it's not just a negative non-interference model, because I think the support model, the support side of things and giving people supports to make decisions and that empowerment as well, for a start that's quite resource intensive to do it properly, and I think that so it's not completely giving people the right to be left alone.
Thank you, Kate.
Thanks.